Good evening. Welcome to a Be Informed session. My name is Carl Buhariwala, and I founded Be Informed to help people make good decisions. Today we'll be looking at independent contractors, and we're joined by Paul Cott, who was previously presented on Be Informed, who will be taking us through who they are and what their rights and responsibilities are. Before we proceed, I'd like to acknowledge the traditional owners of the lands on which we're meeting today and pay my respects to their elders past and present. I'd also like to remind you that the principles and rules today being presented in relation to independent contractors is in connection with the Australian jurisdiction. So if you are considering these materials from a country outside of Australia, please do consider the applicability of the rules and principles being shared. And the information is current as of this month, so if you are looking at this material in the future, you may wish to reconsider the currency of the information. This session is being recorded and will be made available to you following today's session on our YouTube channel. In addition, Paul Cott has kindly prepared a one-page handout which will be shared with all registered participants following today's seminar. And towards the end of the session, after Paul's seminar, there will be an opportunity for Q&A, so please do send through your questions through to me via the chat function, and I will relay them through to Paul for him to consider and respond. We also have received a few questions ahead of the meeting, so we'll start with those before we proceed to the live questions through the session. So with all that in mind, Paul, I think we can commence. I'll hand over to you.
Thank you. So independent contractors, who are they and what are their rights? I think I'll start off by saying that what Carl said before at the end, that the currency of the information that's provided as of today is a good segue into the fact that the law in this area is changing. A bill has just gone through Parliament providing a statutory definition of what an employee is. So that is as opposed to independent contractor. And I'll talk about that in a minute because that new statutory definition is very problematic. So I think we need to go to the next slide, don't we, Carl? So yeah. As we've said there, the differences between them is a very complex area of law, heavily litigated. So what has been the law in the past is that what the court does is look at a range of factors to say whether one is a worker, is a contractor or an employee. And it's been very uncertain. Starting with from 1980 in a case involving bicycle couriers Hollis and Babu, that went all the way to the High Court of Australia, believe it or not, to see what their workers were. And that's how uncertain it was. So if a matter goes to the High Court, that means that potentially 9 judges have looked at it, and it's probably around about a 4-5 decision or 5-4 decision, one in favour of the other. So the previous law has been, as I've said, the multi-factor test. As a result of some cases that went to the High Court again, called Jamsek and Personnel Contracting and Risado, the High Court changed the test to work out the status of a worker, and now said it is what the contract says that the people are, or the worker is, sorry, the primacy of the contract test. So regardless of all the other factors or what the parties might call themselves, it is the primacy of the contract. And I'll just pedal back for a second and say, why are we even talking about what the difference is? Who cares? A worker is a worker. They get paid to do their job and they go home. They have to be safe at work and various things like that. But it really does matter significantly in respect of employment entitlements, in particular annual leave, sick pay, or paid or unpaid sick leave, paid or unpaid annual leave, long service leave, redundancy, and the like. All those things matter because employees get most of those things and contractors do not. Contractors are running their own business. We'll get to that in a second, whereas an employee is not. So going back to the changes in the law. So in 2022, the High Court said that it is the contract that is the key. Now, a bill has just passed through Parliament called the Closing the Loopholes Bill, and they have brought in amazingly, the multi-factor test, where the court looks at a series of factors to say whether one is a contractor or worker. And when I say they look at a series of factors, it's almost a matter of throwing all these factors in and coming out and see what comes out in the wash. So you might have 9 factors pointing to the worker being an independent contractor and 8 pointing towards them being an employee. And the court will say, well, it's almost a toss of a coin, or 9 factors beats 8, so that's what they are. So there's real uncertainty around it, and they brought back that test back in, which is quite amazing to me. And the multi-factor test, which will be the law now, potentially from this point onward, because the bill has just passed through Parliament, is the court looks at a whole series of factors. Control, and who has the right to control. So who tells when and where and how the worker is to do the work? Is tax deducted from the payment? Who provides the tools? Is a uniform supplied, and by who? Can the worker work elsewhere? Generally, employees can't, contractors can. Who pays a superannuation? Although that's a little bit murky now, because some contractors are entitled to superannuation if they provide personal services. Is payment made on provision of an invoice, or is a payslip provided? That's quite important. Generally, of course, contractors will provide an invoice and maybe have an ABN number, whereas employees generally don't have an ABN and they are provided with a payslip. But even those factors themselves are not determinative. None of these factors alone are determinative, so it creates real uncertainty. And even the control test, which is a very important factor, is not determinative on itself. For example, a surgeon, a brain surgeon. Let's look at a brain surgeon doing surgery work at a hospital. There is no way a hospital is going to tell him or her how to do the work. What methods, what method might be better than the other. The only thing that the hospital can tell the surgeon is the hours of work, and while of course they work at the hospital they're engaged at. So as I said, none of them are determinative. They all go into the wash and see what comes out. The ATO on its website has a decision tool. I think you plug in something like independent contractor / employee test, and there's links to a decision tool where you answer a series of questions. That won't be determinative, but the ATO will find that very persuasive as to the status of the worker. So there we go. That's the new test that's coming into play now, the multi-factor test. Thanks, Carl. So as I briefly said before, the essence of an independent contractor is that they run their own business. They're not part of or an integral part of the business they do work for. The presence of an ABN, as it says there, is suggestive, although I've seen quite a few cases, particularly lately, where an employee, for some reason, is told that they have to get an ABN. I don't know why. They give the employer the ABN, and things continue. So even the presence of an ABN, and it might be that the worker has an ABN from a previous workplace, and they have an ABN, but they're not using it to invoice the work in this particular case. Is the worker an integral part of the business that they work for? Are they an outsider? So as it says there, are they on their business's website as listed as an employee, or maybe even as a contractor? Some businesses probably have some people listed on their website, and it might even say that they're a contractor. What are their contact details? Paul at Law and Lydiard, for example, obviously suggests that I'm an employee of my own business. Or do they have their own contact details, so their own business email address with a domain name that's different to the person that they do work for, and the phone number and the phone, along with the tools, is provided by the worker themselves, also suggests that they're running their own business. what we say here, yeah, what the worker or the business they work for considers to be the status of the work is again persuasive, but again, it is not determinative. Another illustration of the uncertainty of the multi-factor test. That the fact that what the worker considers themselves to be is not persuasive is, I guess, a good thing in a sense that there are people who are migrants or whose English is their second language, young people, vulnerable people who don't know their employment law rights. You would certainly not say, well, if that worker then thought that he was a contractor, then that must mean he is one, or if they thought he was an employee, then that means he or she is one. That would not be a factor. So that's fairly low down the chain. A very important thing is that they can work elsewhere. They'll do a job where it might be a day, a week, a year, a month even, at that place where they might look like an employee, but they're not. And I've actually had two cases in particular which stands to mind. One of them involved an application at the Fair Work Commission where the employer said that this worker is not employed as a small business or under a small business. And basically, the upshot of the employer's argument was, well, a lot of our workers, contrary to what our client thought, are not actually employees. Yes, they work here, and they're even provided with uniforms of the business. So our client reasonably thought these workers that she worked with, who she, knew them by their first names, were her fellow employees, but they were not. And that was proved that they were not fellow employees. So she only worked with 7 other actual employees. So the business was a small business. There's another case too where I had a mortgage broker who worked for 38 years as a mortgage broker. He ran the place, or so he ran what he was doing very much as his own business. He came and went when he saw fit. There was no written agreement at all, never had been, never was. He earned commission, he earned a base wage, and he had no idea what he was. He had no idea. And I said, I don't know either. If you want to take this on, we'll have to take it to court, because for 38 years, he never received any annual leave. So if he took that to court and proved to the court, that he was an employee, well, he would have been pretty happy to receive 38 years worth of annual leave, let alone long service leave. Thank you. So the other laws that apply to independent contractors, I mean, they're obviously the laws of the land, so to speak, applies to independent contractors in that contract and consumer laws and the laws of negligence, the normal day-to-day business laws, misleading, deceptive conduct, the common law, statutory law, all the normal laws apply to independent contractors as they do or would to anybody else. However, you cannot claim unfair dismissal if you're an independent contractor. So that means that even if you had a worker who worked at the same business for 15 years and only worked little bits and pieces somewhere else or never worked anywhere else at all, was then terminated or had the engagement ended, he would not be able to claim that he was unfairly dismissed because it wasn't employment. And you don't get the status of being an employee merely by being an independent contractor for a long period of time. Although obviously the court would consider that situation very carefully to say, well, in reality, was he really an employee, and was it sham contracting, which we'll get to shortly. So it might have been that the employer was deliberately not reclassifying the worker's status to make him an employee, which he may well have been in fact. So generally the Fair Work Act does not apply to independent contractors. So the protections there, such as the anti-bullying jurisdiction, where you can make an application to the Commission to stop bullying, does not apply to independent contractors. Some of the other provisions, though, do. So there's a set of general protections that employees have in the workplace, such as not to be discriminated against or have adverse action taken against them for a prohibited reason, such as they're perhaps raising issues to do with health and safety. It's unlawful for an employee to have adverse action taken against them for the prohibited reason. However, independent contractors do have the right to make an adverse action claim or a general protections claim to the Fair Work Commission to have redress of those issues. But generally, the Fair Work Act is set up to protect employees, but there's the odd exception throughout the Act. We also have the Independent Contractors Act. It's a Commonwealth Act, so Australia-wide, but anecdotally, I'm not hearing that it is utilised a lot. There is another law that sits side by side with it. So the Independent Contractors Act, as the slide says, allows independent contractors to ask a court to review a contract that they've entered into with their principal. So an independent contractor would be an agent, and the person who engaged them would be the principal, on the grounds that the contract they entered into is harsh or unfair or unjust or unconscionable, or there's a bit of exploitation and it's unfair to the contractor. There is also the unfair contract terms provisions, which allows anybody in relation to a standard form contract to claim that the contract again is harsh or unfair, and there's a significant imbalance in bargaining power. And so that unfair contracts regime and the Independent Contractors Act allows contractors to ask a court to have a review to say, well, this contract you've been entered into is unfair, and the court can amend some of the clauses, they can rewrite the contract, they can even strike out clauses, amend, and they have a wide range of powers to amend the contract so that independent contractors are not necessarily able to be exploited without the protections that employees have throughout the Fair Work Act and other acts. Thanks, Carl. Sham contracting law, probably a term many have heard of, but it really just means treating a worker, perhaps such as the mortgage broker that I was talking to you about before, who did not want to litigate any claims. He just wanted to go off to the sunset and was happy to enjoy his retirement. But sham contracting is where a business misrepresents or misleads the worker as to the true nature of a working relationship. So, as I said, whether the representations are verbal or written or even implied, so it might not even be any express statements by the business. It might just be, come in, do the work for us. You don't get paid on your leave. You don't get paid sick leave. Christmas shutdown periods, you don't get paid. Various things. Whereas in reality, they become an integral part of the business. Say they might not have an ABN. They're provided a pay slip. They don't get paid on provision of an invoice, and they get tax and super taken out. So that in that situation, that worker has all the indications that they are really an employee, but they're treating the the worker as an independent contractor, potentially to avoid the obligations to pay payroll tax, workers' compensation insurance, paid on your leave, paid sick leave, redundancy pay, the end of the relationship, and the various duties that are owed to employees by employers. So penalties can apply, and they're pretty hefty at the moment, or at the time of writing. The penalty for an infringement of the sham contracting provisions are $18,870 for an individual and $93,900 for a corporation. That is per infringement. But however, the infringements or the offence does require either knowledge or recklessness on the part of the business. So it's not just a case, well, in reality, they're an employee. therefore there's a penalty that applies. Sometimes it's inadvertence, but all these things become a matter of evidence if it went to court. It is also an offence, as the slide says, if a business denies the benefits legally available by treating the worker as an independent contractor, when in reality, as I've said, they are an employee. It is also an offence to influence an employee to be an independent contractor rather than an employee, for the employee to potentially have those benefits avoided. And it's also an offence if the business terminated the employment of an employee and then re-engage them as a contractor purely to avoid the entitlements provisions of the Fair Work Act. So if you're an employee, what you should do, if you are uncertain as to a relationship, ask the question of the employer, perhaps seek some advice, and report it to the ATO is one possibility. You may report it to the Fair Work Ombudsman. The body is set up to basically deal with employment entitlements. Make an application to the Fair Work Commission or get legal advice. Thanks, Carl. And the responsibilities of independent contractors. So as they are running their own business, they have all the responsibilities and rights and entitlements, I guess, of any business owner. They have to abide by and comply with their own taxation obligations, perhaps any business licensing provisions, such as in my field, a lawyer, you have to get your own principal practicing certificate. You can't be an employee. You can't have an employee practicing certificate to run your own law firm. Occupational health and safety obligations. The normal legal obligations, such as to not act negligently, to not exploit people, manage their own finances, prevent trading whilst insolvent or suspecting insolvent, as any business owner has an obligation to do so. They should make, although they're not legally required to make provision for their retirement. And a lot of people who are independent contractors or who are directors of companies have their own self-managed super fund to provide for their own retirement. And there are many experts around who specialise in setting up self-managed super funds. Any independent contractors would have to arrange their own insurance obligations, whereas generally employees don't, such as public liability insurance, any building insurance, or building or home and contents insurance, professional indemnity insurance, or all professions, engineers, accountants, and lawyers are meant to be insured. Workers' compensation insurance, and if the independent contractor hires employees. So that's the other thing that an independent contractor may do. They may actually be an employer themselves. And of course, independent contractors must abide by their own normal standard contractual obligations in relation to any contracts, whether they're verbal and written. And also, if the independent contractor runs the business through an incorporated company, which is quite common for taxation and avoidance of liability provisions, you will have reporting obligations to the Australian Securities and Investments Commission. Thanks, Carl.
Thanks, Paul. So Paul's details are on this screen. If you have any further questions, please do not hesitate to reach out to him. Paul's been a sort of an avid supporter of Be Informed and regularly contributes to these sessions. So we thank him for his time and for sharing that very informative seminar.
Carl, can I just briefly swing back just from not even a minute on something?
Yeah.
So when we said that now the new laws coming into play where the multi-factor test comes into whether a worker is a contractor or an employee.
Yeah.
I've got this quote from a case, and it involves some on-call interpreters and whether they were independent contractors or running their own business.
Yeah.
And it's talking about at the time when the law said that there was a multi-factor test applied and there was no clear statutory definition. It said the absence of a clear, simple and clear definition which explains the difference between an employee and independent contractor is problematic. Workers and those who employ or engage them require more clarity from the law. And so, as I said, it's very ironic, I think, that all of a sudden we are now got statutory changes. The law is now just passed through Parliament that brings the multi-factor test in with all its uncertainties.
Yeah, there's definitely been a lot of swings and roundabouts with the rules. I've been, as a lawyer myself, I have been following all the changes, and it just keeps on going backwards and forwards. And now with the statutory changes, it sort of adds that additional level of complexity.
Well, it does, and employers are often crucified for underpaying their workers, which obviously I don't agree with, but it's a real minefield out there for employers to come across what their employment law obligations are. And employment law is probably been the most had the most subject to the most changes in this area in history.
Yeah,
Ever.
oh, I agree. All right, so we'll move on to Q&A, and some
Yep.
of the themes will actually be raised through that as well, Paul. Just as a reminder, this session is being recorded and will be made available following the session on our YouTube channel. Paul has also prepared a one-page handout which will summarise the seminar, so that will go through to registered participants by email. So we'll start off with some of the questions we've received ahead of time, and Paul sort of touches on the point you just raised earlier around, employers needing to really understand their employment law obligations and how it applies. The question we've received is in relation to an individual who I assume is running a business, and he or she hires, or they hire various contractors. What systems can they put in place to ensure that those contractors just remain contractors and they don't sort of morph over time into employees, which then opens up other sort of obligations on the employer? So what sort of operational or risk processes can they put in place that you've sort of come across, Paul, that can help ensure that they're not sort of veering into that space?
I think they have to carefully consider, particularly in light of the new law now, they have to carefully consider all the incidents, what they used to call in the High Court. They look at the incidents of the relationship. What, who's taking the tax out? Who's paying superannuation? Who provides uniforms? Who controls the work? Or if they don't control, who has the right to control? All those types of factors. Can they delegate? Can they work elsewhere? You have to look at the totality of the relationship, all those things, and weigh it all up. And look, and I don't want to mislead anybody by saying that it's unclear in every case, because sometimes it's clear. Somebody is an employee, somebody's a contractor, and there's no question, there's no issue. So generally, if you look at all those incidents of the relationship, then you'll know what they are. It'll be clear. It's only when you get blurred lines and many factors pointing one way and many factors pointing the other that it becomes uncertain.
Yeah. So it might be worthwhile for those people that are running their own business and they do engage contractors to support with their operations to sort of consider those incident factors in totality and sort of how they engage with those individuals to ensure.
I think the two, perhaps if you had to pick any of those factors out as being more important than the other, is the right to control the manner, how and when and where the work is done, and also can the worker work for other, or can they work elsewhere? If they can work elsewhere, they're probably not an employee. If there's a right to control, then they might be an employee.
And it's quite interesting, Paul, you raised that, because currently we are seeing in various sort of industries, especially in the gig economy as well, sort of the temporary workforce arrangements where you can work at multiple sites. In aged care, it might be, or in hospitality or in health, because there is a shortage of staff, so they are trying to promote that flexibility to encourage people to weigh in on those opportunities rather than just being dedicated to one employer.
Well, that's right, and that raises the issue of labour hire. We haven't even touched on labour hire.
Yeah.
So is a worker who's engaged or on the books of a labour hire company says you go out on that site, and for the 4 days of the week, and the other day you can do whatever you want. Are they an employee or a contractor? That's a tricky one.
Yeah. So how do you see it playing out with the sort of, with your understanding of the new statutory rules that are coming into play? Do you think this will deal with that issue, or does it just cause greater uncertainty, especially in the current industry landscape and how workers are being engaged?
It brings back the old uncertainty of the old law. As I said, in 1980, so that's what, 43 years ago, the matter was being litigated, or this type of issue was being litigated all the way to the High Court, just involving bicycle couriers. So, look, in the end, it didn't really create as big a problem as what I might be seen to be making out, because in most relationships, it's clear what they are, and even though the primacy of the contract test is not the law anymore, if you have a written employment contract that says employment all over it, or if you have an agreement or an independent contractors agreement that has independent contractor all over it, then it's probably one of them.
Yeah.
But it's not. The contract will not be the only issue now that the courts will look at. They may wish to also look at all the other things, because if there is a written employment contract, but they are paid on ABN, and they give an invoice, they don't get pay slips, they can work elsewhere, they don't get paid annual leave, then they might be a contractor, even though they've got an employment agreement. Now, this new test coming into play does create the uncertainty again, but I'm just hopeful that it's not going to be as uncertain as what I'm making out.
And Paul, just on that, we've had a question around: can someone be misled about whether or not they're an employer or an independent contractor? So based on the information they get from the employer or the principal, because it depends on the relationship. Have you ever seen that in your experience, with individuals being sort of misled about what they're actually entitled to based on the status in the?
I've had a lot of inquiries about it where, well, the employer keeps telling me that I'm a contractor, but I've got a feeling I'm an employee. None of them have gone to court. Basically, the employee, in many cases, can't afford to go to court and litigate the issue. So it's not an issue that's litigated very heavily for that reason. But that's where I've had the inquiries around people who are a bit uncertain themselves as to what they are, and then getting people talking to them and saying, "Oh, I read this thing the other day, and it might be that you're actually an employee." "Oh, but I've always considered myself to be a contractor because I can work elsewhere. I just haven't got any other work anywhere else. I haven't applied for it or tried to get it." And then the uncertainty is created. Or what often happens is, they're allegedly unfairly dismissed. They're an employee, and they file an application for unfair dismissal, and the employer says, "Yeah, but you're a contractor. So this matter can't be heard by the commission." And so then that shows that potentially the employee didn't even know what they were, because employees don't think about it. You go to work, you do your job, you get paid, and especially young ones, as I said before, the young workers, and migrants or people of a second English language are often just not aware of these things, and there can be some exploitation, but I haven't experienced it too much in practice.
Yeah. We've had a question all around, if you could just explain briefly the difference between a casual employee and a contractor.
Yeah, no, that's a good question, because these new laws also now have a statutory definition of what a casual is. Well, and sometimes, yes, there is a real uncertainty around, is a worker a casual employee because they can work elsewhere, or are they a contractor? But you have to go back then to the fundamental test. Forget whether they're casual or part-time or full-time for the moment. Just work out, are they an employee or a contractor? If they're an employee, then they're a casual. So I know that often the things look very similar, And there's the old saying about, if it quacks like a duck, it is a duck. But sometimes a duck might sound like a duck, but it's a geese. So
Yeah.
sometimes a casual employee and an independent contractor can be even more similar than a full-time employee and a contractor.
Mm.
But it comes back to the test, which one are you? And now it'll be the multi-factor test. However, if there is a written agreement in place, that'll be persuasive.
Right. And Paul, just to remind the people on the call today, superannuation, do casual employees and contractors get superannuation alike, or is it different?
Casuals don't, but independent contractors generally don't, but they do. Now, I think the law changed about 3 years ago where if you're an independent contractor and you provide what's called personal services as defined, I haven't looked at the definition for some time, such as professional services rather than manufacturing or retail. If you provide personal services as an independent contractor, your principal is now meant to pay you superannuation.
Yeah. So just on that point, I think, Paul's profession as a lawyer is different to sort of an accountant or a financial advisor. So if you have any questions in relation to superannuation, how that operates, recommend you consult with the appropriate professional.
Yeah.
Paul, just back to the questions that we've received around sham contracting laws. I suspect this individual is probably a foreign background and has been contracted to do. The question sort of talks about, I guess, courier services, and I think we've talked about this in the past as well, sort of a high risk area, driving around or maybe riding a bicycle and delivering goods and services.
Or Uber drivers and
Yeah.
Deliveroo, all of those types of businesses. That's been litigated in the UK, and they've got an opposite result with the same type of workers in Australia.
That's right. Yeah. So this person sort of feels that they're not receiving a particular entitlements that they might be entitled to, because they're working sort of regular hours and they're using the equipment and sort of the vehicles provided by the employer, by the organisation. Now the organisation is saying that this person is an independent contractor. What sort of steps can that person take actively to sort of challenge the position?
So the first thing I would say is there a written agreement? If there isn't, raise it with the employer and say, which one am I? Because I'm aware now, whereas they may not have been, I'm aware now that employees, if I'm an employee, I get benefits to which I'm not entitled as an independent contractor, and I just want to create some certainty in my mind as to which one I am. Also, so if you don't get any joy there, I mean, you should, because you should be able to raise reasonable questions with your employer and not be penalised or victimised or discriminated against because you do that. In fact, there are laws in place to protect you, and not face adverse action or backlash as a result of asking questions. But if you don't feel comfortable or if you don't get a straight answer from your employer, the Fair Work Ombudsman is pretty good in respect of they've got a phone advice service. And what I would do if somebody was to ring the Fair Work Ombudsman and said, "Well, this is the nature of my relationship. What do you think I am?" They may or may not get a straight answer, but what I would do if I was the employee is take down the date, time, and the call, the person who gave the advice, and record it. Write a file note recording the details of the phone call and who said what and why. And again, go back to the employer and said, "This is the advice that I've received," and put it back onto them. I mean, the onus is on the employer to set the relationship up so that both parties are clear and certain as to what they are and what the rights and entitlements are. And if it's muddy, then it's a failure of the employer and maybe sometimes the employee. But primarily the onus is on the employer.
Mm. And just on that point, if someone does end up sort of having a dispute with their organisation, and I say organisation because it could be an employer or a principal under a contract arrangement, they do end up having a dispute, and the nature of the agreement sort of suggests that it's an independent contract. They can't really go to the Fair Work Ombudsman, right? Because that's sort of out of scope there. It becomes a contractual issue. What do you recommend they do to deal with the situation? Is there any sort of dispute resolution body that they can attend, or mediation, or do they basically have to challenge the contractual nature of the arrangement through the courts?
Yeah, it might have to be determined or get legal advice, but it may need to be determined by a tribunal or a court.
Mm.
In those processes, so say an application was made, this is Victoria, in the Industrial Division of the Magistrates Court for some unpaid entitlements, then there'll be a mediation anyway as part of the process. So there'll be a mediation as part of the court process, and you might be able to resolve it that way.
Right.
You're right, because that sometimes shows the big gap in this protection for independent contractors. I mean, the Independent Contractors Act, as I mentioned before, is good to have a contract review that's harsh, and it may be that you might be able to use that to look at exploitative terms where they might not be getting annual leave and so forth. But generally, there is still a bit of a gap for independent contractors. Employees are protected through the bargaining that unions have had over the years with the government, and laws have been put into place to protect employees. But there's still a gap in protection for an independent contractor.
That's right, and the Independent Contractors Act, to my understanding, as you say, it's not used as much as maybe they would have hoped when they put that piece of legislation through.
No, that's right, and I think more people have become independent contractors. And what I noticed when COVID finished up is that, or even before it did, where a lot of employees may have lost their job through not agreeing to the vaccine mandates or the business going redundant or so forth, they set up their own business. A lot of people set up their own business as independent contractors, so they're then all of a sudden in a contractual relationship, which they probably know nothing about when they set it up.
Definitely. So I think, yeah, those that have sort of spawned following COVID or just at the end of it should sort of reconsider what the arrangement is and what sort of entitlements they receive.
Yeah.
Based on the contract, whether it's written or just not written. There's one question around sort of unwritten arrangements, which sort of touched on the previous question before, and what can they really do to prove what was discussed? Most of the times they don't really take any records. They're just probably driven to getting a paycheck or getting their invoice paid, as opposed to really thinking about the details. So I think you've touched on before that it's worthwhile sort of keeping a record of what was discussed and what's currently happening, and probably consulting a legal professional to help you sort of go through that multifactorial test to determine which factors you do satisfy from a employment perspective, which ones you don't, and that can sort of help determine sort of what status you are. Paul, we've got another follow-up question, which I know what the answer will be. Sort of, I think you need to look at the contract. We talk about the responsibility of the independent contractor, but one person's asking, well, what are the responsibilities of the principal? And of course, that'll probably be driven by what's exactly written into the contract. But are there any sort of statutory protections that they receive other than from the Independent Contractors Act that you can think of?
Well, no, apart from you could make an application to a court to say, pursuant to the Independent Contractors Act or pursuant to the unfair contract terms regime, that this contract I've entered into is harsh or it's unfair on me. There's an imbalance in bargaining power. I was just presented with it. I couldn't even negotiate any terms. And the principal said, here's a independent contractor's contract. Take it or leave it. If you don't agree to it, then you don't get the work. So there are those avenues to have contracts reviewed. So there's a fair bit of scope within them to have them reviewed. But yeah, it does depend on the terms of the contract.
And you touched.
Yeah, and sorry, you don't have to have a contract in all cases. And when lawyers say to clients, well, you should have a written contract or it should be a written agreement. Yes, there should be, and we're not saying it for no reason. We're saying it because in the event of a dispute, you have to go back to the oral evidence. Who said what? And you can guarantee that one person's recollection of what was discussed over many years, over many courses of dealings and conversations is going to be different to another person's, and that's going to be different to another person and different to another person. So just too much uncertainty. So even though the primacy of the contract test has been put aside now, in all cases, you're going to take your dispute a long way. You've got a written contract in place, even if it's not 20 pages, even if it's only 4 pages or 3 pages, it's better than nothing.
Definitely. Yeah, I think just keeping a record of those discussions is very useful, especially when there's a degree of uncertainty on both sides as to what the relationship is. At least you've got something to sort of trace back to. And
Yeah, I mean, sometimes it's a bit going over the top to say, well, if you have a discussion with your HR department on a particular day, go home that night and write down what was said, date, time, and who you spoke with. I mean, that's a bit unrealistic to expect employees to have to do that. But, if you did do it, it might stand you in good stead later on down the track.
it's interesting you say that. Just 2 points I'll raise, and the first one just around HR. Like, a lot of small businesses probably don't even have a fully fledged HR or employee relations sort of division, right? So it's probably just the founder or someone in sort of a managerial position probably taking on that responsibility. So it's always sort of a good idea to really consider, what discussions you do have with them, and make notes. So even if they're not sort of well versed in the specifics of those arrangements, at least they're providing you with some level of detail that you can then review and assess and consider whether or not you are an employer or independent contractor. And finally, Paul, you mentioned around the unfair contract terms, which is quite an important point, because there is the unfair trading practices sort of consultation currently, being held by the Australian government, and just thinking about the breadth of that regime and how it can apply to independent contractors' contracts, I think is quite pertinent, because even those terms that may seem to be favourable to the principal, or the contractor might just take them on because they want the work and didn't really look too much into it. They may actually find that they're actually potentially unfair and could prima facie actually destroy the entire contract, all those relevant clauses. So it's always worthwhile sort of keeping that in mind if things do go pear-shaped, because you might be able to use that as an avenue, as you mentioned.
And the unfair contract terms regime has just been strengthened. They've increased the penalties. They've made it easier for people to prove claims that contracts are unfair. So they have actually really strengthened that law fairly recently. The penalties are huge now. But so the first qualification is it has to be a standard form contract. So what that means is, as I said before, for example, gym contracts, telecommunications contracts which are just, all right, here's the service, but here's our contract. So you don't have any opportunity to negotiate it. There's got to be a standard form. If it's not a standard form contract, in other words, one that gets given without the other party having a chance to negotiate it, and one that may get given all the time to people in the worker's position, then it's not able to be reviewed under that regime. But as I said, that regime is not something I work on very often, but it's just been strengthened. So it does have some more legs than what it used to have. And I think it was a recognition that contractors were being exploited at times, and in ignorance through no fault of their own or their own legal rights.
Yeah, definitely. Thank you, Paul. That was an excellent discussion and session. Paul's details are again on screen, so if you do have any questions, feel free to reach out to him directly. And just some closing remarks. So just a reminder, this session is being recorded and will be shared on our YouTube channel following the close of today's session. Paul has also prepared a one-page handout which will be distributed by email to registered participants that contains a summary of the matters he's talked about today. Please do follow us on social media and share with your friends and family the session you've attended, so more people can continue to be informed and make good decisions. Our next session is on Wednesday, the 25th of October, which will cover our parenting responsibilities following a divorce. So if you have anyone that needs assistance in that space, tell them to attend and register, for that session, because there'll be some useful information shared by a family lawyer. Other than that, that brings us to the close of the formalities in the session. Thank you, Paul, once again.
Thank you. Can I just say what a great initiative be informed is, I don't know whether it's ever been done something like this before, but to me, the professional manner in which Carl conducts himself with this be informed avenue is really good, and I don't think that he gets anything out of it apart from helping people to be informed and make good decisions in their everyday lives. And I think that he should be commended for it.
No, thank you, Paul. Yeah, as you've said, this is really altruistic. There's no sort of no payment, nothing, and even Paul's time as well is all voluntary today. So we thank all our presenters who take the time out of their busy schedule to share very important information that's unbiased, purely objective, purely factual. So people that are listening today or listening in the future can continue to be informed and make good decisions. So thank you, Paul, for those kind words, and thank you for your time. And
Thank you.
that brings us to an end. All right. Thank you all. Bye for now.
Thank you.